illegal immigration continues to be a political hot topic. In some cases, undocumented immigrants pay another person for safe passage into Texas. The Texas Penal Code offense of smuggling of persons applies to those persons who arrange for or participate in smuggling illegal immigrants into Texas. According to the Penal Code, a person commits the offense of smuggling of persons if they knowingly use a motor vehicle, watercraft, or aircraft to transport an individual with intent to conceal the person or flee from either a peace officer or federal law enforcement officer who is trying to arrest or detain them. A person also commits this offense if they encourage, induce, or help a person enter or remain in the country in violation of federal law by concealing, harboring, or shielding that person from detection. Or finally, if a person assists, guides, or directs two or more individuals to enter or remain on agricultural land without the effective consent of the owner, they also commit smuggling of persons. It's important to note the Penal Code provides an affirmative defense if the actor is related to the victim or is an immediate family member. So, for example, a father and mother crossing the border with their children would have an affirmative defense. Keep in mind, this is not an offense to be charged against the person who enters the country illegally. That's covered under federal law. It's primarily an offense for someone who is making money off of concealing an illegal immigrant from the police or transporting an illegal immigrant and fleeing from police. Be careful not to read too much into the text of the statute, as there has been much litigation surrounding its constitutionality. For instance, in 2016, the Texas Department of Public Safety provided a statement to the U.S. Court of Appeals for the Fifth Circuit that Texas would not prosecute landlords who rented to persons the landlords knew were in the country illegally under this statute. If a person who was smuggled became a victim of aggravated sexual assault or sexual assault, the actor will be charged with a felony of the first degree. If the smuggled individual suffered serious bodily injury or death, it's also a felony of the first degree. All of the following make smuggling of persons a felony of the second degree. If the offense was committed in a manner that creates a substantial likelihood the individual will suffer serious bodily injury or death, if the offense involves a child younger than 18, if the actor committed the offense in order to obtain a pecuniary benefit, in other words, gain some sort of financial or other advantage, if during the commission of the offense, the actor, another party to the offense, or an individual assisted, guided, or directed by the actor knowingly possessed a firearm, or the actor fled from either state or federal law enforcement. All other offenses are felonies of the third degree. We've already discussed the offense of smuggling of persons. The offense of continuous smuggling of persons is meant for those cases where a defendant is repeatedly smuggling persons, likely as part of an organized operation. According to the Texas Penal Code, a person who, during a period that is 10 or more days, engages in the offense of smuggling of persons 2 or more times commits continuous smuggling of persons. Note, a defendant cannot be charged with both smuggling of persons and continuous smuggling of persons for the same act or acts. If a sex offense results from the act, then the offense is charged as a felony of the first degree and carries a mandatory prison term of life or 25 to 99 years. If serious bodily injury or death results, there is also a mandatory prison sentence of life or 25 to 99 years. If during the course of the offense there was a likelihood of bodily injury or death to the victim, the offense is also charged as a felony of the first degree. If the person smuggled is a child younger than 18, again, the offense is a felony of the first degree. All other offenses are felonies of the second degree. The offense of operation of a stash house will likely be encountered under the context of smuggling and trafficking of persons offenses. According to the Texas Penal Code, a person commits operation of a stash house if the person knowingly uses or permits another to use any real estate, building, room, tent, vehicle, boat, or other property owned by the person or under the person's control to commit smuggling of persons, continuous smuggling of persons, trafficking of persons, continuous trafficking of persons, aggravated promotion of prostitution, or compelling prostitution. While the statute already mentions the offense may be committed by a person who permits their property to be used for these purposes, the Penal Code goes on to specifically state renting or leasing any property to another, intending that the property be used for these purposes, is included in the elements of the offense. All offenses under the statute are A misdemeanors. Finally, if conduct that constitutes an offense under this section also constitutes an offense under another law, the actor may be charged with operation of a stash house, charged with another offense, or charged with both. Before talking about the Texas Penal Code crime of trafficking of persons, we need to review some specific definitions related to the offense. First, the Trafficking of Persons statute defines a child as someone younger than 18 years old. Coercion retains its definition from Penal Code Section 1.07, which you'll remember means a threat, however communicated, to commit an offense, inflict bodily injury in the future, accuse a person of any offense, expose a person to hatred, contempt, or ridicule, harm the credit or business reputation of any person, take or withhold action as a public servant, or cause a public servant to take or withhold action, and also includes the following when used in the context of trafficking of persons offenses: destroying, concealing, confiscating, or withholding from a trafficked person, or threatening to do the same to a trafficked person's actual or purported government records or identifying information or documents; causing a trafficked person without that person's consent to become intoxicated to a degree that impairs the person's ability to appraise the nature of or resist engaging in any conduct, including performing or providing labor or services, or withholding alcohol or a controlled substance to a degree that impairs the ability of a trafficked person with a chemical dependency to appraise the nature of or resist engaging in any conduct, including performing or providing labor services. So in these three cases, coercion includes essentially holding on to a trafficked person's passport or threatening to destroy it, getting a trafficked person so intoxicated they cannot resist the trafficking, or withholding drugs or alcohol from a trafficked person who has an addiction in order to prevent them from resisting. Next, the Trafficking of Persons statute defines forced labor services as services other than sexual conduct performed or provided through the actor's use of force, fraud, or coercion. Next, the Trafficking of Persons statute defines sexual conduct as including sexual contact, actual or simulated sexual intercourse, deviant sexual intercourse, sexual bestiality, masturbation, sadomasochistic abuse, or lewd exhibition of the genitals, the anus, or any portion of the female breast below the top of the areola. Finally, the Trafficking of Persons statute defines the word traffic or trafficking itself as transporting another person or enticing, recruiting, harboring, providing, or otherwise obtaining another person for transport by deception, coercion, or force. The Trafficking of Persons offense found in the Texas Penal Code applies to behavior that is more sinister than the offense of smuggling of persons. Instead of just transporting or concealing humans for money, trafficking of persons involves the knowledge that those persons will be forced to work or prostitute themselves, or the trafficker will be receiving some sort of benefit or payoff for the forced work or prostitution, essentially profiting from those persons being held in modern-day slavery. There are generally two end results in the Trafficking of Persons statute, either forced labor or forced sexual conduct. We have previously discussed their definitions. First, the Penal Code states a person who knowingly traffics another with the intent they will engage in forced labor or services or benefits from participating in an activity using forced labor commits the offense of trafficking of persons. Second, a person commits the offense of trafficking of persons when they knowingly traffic another person and through force, fraud, or coercion cause them to engage in prostitution, solicitation of prostitution, promotion of prostitution, online promotion of prostitution, aggravated promotion of prostitution, aggravated online promotion of prostitution, or compelling prostitution. A person also commits the offense of trafficking of persons if they knowingly engage in sexual conduct with a person who is trafficked for that purpose, receive a benefit from the trafficking of any person who is trafficked for the purposes of sexual conduct, traffics a child with the intent the child engage in forced labor or sexual conduct, or receives any benefit from the trafficking of a child who is forced into labor or sexual conduct. Trafficking of persons involving a child, the death of a victim, or the death of an unborn child of a victim is a felony of the first degree. It is also a felony of the first degree if the actor recruited, enticed, or obtained the victim of the offense from a shelter or facility operating as a residential treatment center that serves runaway youth, foster children, the homeless, or persons previously subjected to human trafficking, domestic violence, or sexual assault. The final felony of the first degree enhancement for trafficking of persons is punishable by imprisonment for life or for a term of not more than 99 years or less than 25 years if the actor committed the offense in a location that was on the premises of or within 1,000 feet of a school or where an event sponsored or sanctioned by the University Interscholastic League was taking place. All other trafficking of persons offenses are felonies of the second degree. The Texas Penal Code offense of continuous trafficking of persons is intended for those defendants who repeatedly profit from what is essentially modern-day slavery. According to the Penal Code, a defendant who commits, during a 30-day period, 2 or more acts of trafficking of persons against 1 or more victims has committed continuous trafficking of persons. Note, according to the Penal Code, a defendant cannot be charged with both trafficking of persons and continuous trafficking of persons for the same acts. All continuous trafficking of persons offenses are felonies of the first degree, which carry a mandatory prison term of life or 25 to 99 years. A few things to note. According to the Penal Code, for the offense of continuous trafficking of persons, if the jury is the trier of fact, then the jury need not agree unanimously on the exact dates of the instances of the offenses, only that the defendant committed 2 or more acts within the 30-day period. Finally, a party to the offense, so in this case likely a victim who was being trafficked, could be required to furnish evidence or testify against the defendant. If this is so, according to the Penal Code, the party to the offense cannot be prosecuted with the evidence or testimony they provide, except for aggravated perjury. In any case, a defendant may be convicted of continuous trafficking of persons based upon uncorroborated testimony.